Our next presentation is from our friend George White. He is currently a prosecuting attorney. He was a former prosecuting attorney for the City and County of Honolulu Office of the Prosecuting Attorney. Okay, I'll let him introduce himself.
Good morning. I'm no longer with the prosecutors. I was a prosecutor for a couple years. I'll give you a brief bio of me. I'm born and raised in Hawaii, went to University of Hawaii Law and got a certificate in environmental law. And I'm a little bit nervous coming up after Alexa Cole because she was one of the enviro mentors that they hook us up with at the law school to try and learn from the best in the business, and Alexa's definitely considered one of them. But right out of law school, or throughout law school, I worked at the prosecutors as a clerk, and then I became a prosecutor after passing the bar exam. Now, to follow up briefly on what Alexa was saying, first, the only time you want an exclamation mark in a report is if it's an utterance and it says, "I did it," or something like that, where it's an exclamation and they use that exclamation mark. But Alexa's right, you don't want to add any inflection of emotion or anything like that. I'm glad that Alexa had such a thorough presentation to discuss the civil side of enforcement because what I dealt with, but what I'm also familiar with, is the criminal side. The civil side is a lot easier to a certain degree. At the level that Alexa's at, it's obviously very complex, but it's simpler in its burdens and it's simpler in its enforcement capabilities. Once you come into the criminal world, there's heightened protections for everybody that's involved, and there's heightened procedures, and you're facing the possibility of jail time usually. Basically, the way that the state is set up is such that there's the state statutes, the state administrative rules, and regulations, as well as the various agencies also have their own respective rules. When you're looking at these laws, what those provide for us, they're already in place. I know Alexa talked about drafting certain things. DLNR has a whole slew of laws that are authorized for them by the statutes and then their own respective rules. The civil side of stuff that DLNR does certain amounts of right now, but they have the mechanisms in their rules already to go forward with the civil side of things. Right now, though, the law and the HRS, the statutes, and the administrative rules are set up in such a way that provide the environmental protections like prohibitions on fishing or prohibitions on certain activities in conservation areas or those types of activities. The problem is that they are set up strictly for criminal liability at this point. What that means is people can't just pay a fine and not have to show up to court. Now, it's very important to have that hammer available for those that would violate our natural resources intentionally. But the goal, I think, in the coming decades is to encourage more civil enforcement, more community-based participation in which you can find people and not have to have them have an attorney and go through the whole legal process. Alexa's right that basically the way that the state laws are set up through the statutes and the administrative rules, all prosecutions for environmental related offenses come through either the Attorney General's office or the Office of the Prosecuting Attorney. In most cases, my understanding is it comes through our office first, at least for the island of Oahu, and then we will defer it to the Attorney General's if that's appropriate or not. Now, while I was a prosecutor for 2 years, most of your environmental related offenses are what they consider misdemeanors. That is where you face the possibility of a year in jail and or a $2,000 fine. There's also petty misdemeanors, and even in some cases, intentional killings of animals can raise it to a level of like a Class C felony, which is very bad. 5 years in jail, $10,000 fine, and it's not good for you. When you're dealing with these various types of penalties, they go through certain courts. Now, for misdemeanors, they go through what they call the district courts of each island. So in this case, for the island of Oahu, there's 5. Kaneohe, North Shore for Kapolei, Ewa, Honolulu, and I believe there's one more, Wahiawa. Wherever the violation occurs, that is where they will be referred to. Now, how do you get caught for violation? Let's give some samples. Kids hiking Stairway to Heaven, which is a closed state land hike. Because of danger for kids falling off a cliff or for hurting yourself, we have prohibited you from accessing that. At certain moments, DLNR or even HPD will be there and they will issue citations to individuals who are caught coming off of that trail. And when they do that, they're given a citation to appear in court in 30 days and they show up to court. The process is that when an officer issues a citation, like an HPD officer or DLNR officers, which are held at the same level of enforcement capability, those citations come into our office and we screen them. Like Alexa said, as far as looking at a citation, the elements, what you need to prove, you have certain things you have to look at and determine whether or not you can charge this person with a crime. What I'm going to try and do is just give you a few stories, and hopefully that'll break it down into kind of the basic questions of what makes for a successful prosecution, what makes for a failed prosecution, or in certain instances when you don't even need to prosecute because people are following the law. I feel as though I'll start with the failed prosecutions first, and then we'll talk about better things after that. Couple stories. When I was a prosecutor, I was in district court for about a year, and then I moved up into circuit court, which is your more serious felonies. In district court, like I said, we handle all of the environmental related citations issued by DLNR. Rarely will the AGs get involved unless there's a major initiative or some sort of major thing other than the day-to-day type of citations that are issued for environmental related offenses. So we received about 24 citations to a bunch of individuals who had gotten off the boat at Honolulu Harbor, and they were carrying a bunch of akule or mahi-mahi, and they had just come off a big fishing boat. And an officer issued about 24 citations to each individual for possessing these dead fish. Now, he cited them under a law that basically requires you cannot fish for this unless you have a commercial license. And so we can prosecute him or prosecute those individuals for not having a commercial license and having those fish. We're looking through the citations, and I believe the officer in the back mentioned the specificity of reports and the ability to communicate with your enforcement officers and talk to the prosecutor, like Alexis said, to take you out on a boat, to take you out into the resource and to see what you're working on. In this case, the officer issued these citations for no commercial license. I'm reading the reports and I'm looking through them and I go to the law. Now, nobody had given me the copy of the law, but luckily I care about my job enough that I really went through the administrative rules and looked at what was required. The problem was, these citations we could not charge a crime for, because under the statute, there's two separate standards for land-based mammals or land-based animals and sea-based animals. And the definition of take is different for sea-based versus land-based. And as I'm looking at the elements and the citation and the facts, in this case we have guys walking off the boat with these fish. They clearly went fishing and got them all. They're one of these major fishing vessels. None of them had a commercial license. But the problem was that the statute was worded in such a way that the DLNR officer had to observe the killing or taking of that fish, not the mere possession, which would have been what they consider a strict liability. Like Alexa said, it's our golden. When they just have it, we're great. Like when somebody has drugs on them, there's pretty much not many good defenses somebody can have. But with these 24 citations, I had 24 cases I couldn't prosecute because I couldn't prove that those individuals possessing those fish were the ones that killed it. And that's what the law required. Now, that's a failed prosecution. We didn't go to court with it because we couldn't charge it. One funny side story to that, though, is I got a call from the attorney representing about 5 of these or 6 of these individuals that had gotten cited, and their arraignment date was coming up, and they said, I already reviewed it, I know what I'm going to do, but the attorney says, I think you have a problem with this case, or these cases. And I said, oh really, what is that? And he goes, look, you can't issue a citation to an illegal immigrant or an illegal alien. And I said, oh, are you telling me this? If if he shows up at arraignment and tells the judge that these people are illegal aliens, that's on the record of a court of law, and good luck getting any sort of a... Now granted, that didn't happen because we couldn't charge this case to begin with, but it's interesting what, when you pick up one stone, what ends up happening. Another example of a failed prosecution, and this one went to court, 2 great defense attorneys against one of our prosecutors. This was an issue of shark jumping out North Shore side. DLNR did a terrific job with their reports, very thorough, detailed. They provided the applicable laws that they thought were applicable, just for our reference. They provided detailed reports, GPS locations, everything was spot on. We even had video of the shark jumping going on. We charged them, we showed up to court multiple times. This is an ongoing process, and it's pretty serious charges. It was 2 separate boat operators. But the defense attorneys filed a motion to dismiss. And the reason they filed the motion to dismiss, actually they filed a motion to compel discovery, to get information. And the reason the prosecution failed was not because of DLNR or because of the Office of the Prosecuting Attorney. The reason the prosecution failed is because one of the elements that you need to prove when you're proving the shark chumming is where did the shark chumming occur? Did it occur 100 feet from shore? Did it occur 2 miles off of shore? In this case, DLNR was right on top of it. They had their GPS locator, a really good one, and they knew the exact coordinates, and that was within the 3-mile jurisdiction of my prosecuting power, meaning I can charge a case if it's up to 3 miles outside of our offshore. Defense attorneys were very smart though, and what they asked for was the manual that instructed the DLNR officers how to use this really fancy GPS locator thing. Now, we obviously said, Judge, they don't need that manual. They don't need, the GPS thing speaks for itself. Problem was, the GPS locator that DLNR used was a GPS locator provided by the federal government through the DEA, and the DEA uses this GPS locator specifically for drug runs and drug operations to make sure, to pinpoint where the boats are running and all this stuff. So the feds basically said, we will not turn over the manual because they didn't want it to become any part of any record or anything like that. Without being able to provide the manual so that the defense attorneys could cross-examine the witnesses, we were unable to establish the location at which the shark chumming occurred. And you can't have a DLNR officer say, oh, it looked about 2.5 miles. That's not, we needed a precise location. The problem is we couldn't prove the location. Very unfortunate. We did our best to say, feds, give us the book, we'll put it under seal, we'll do what we can. But unfortunately, that one fell through the cracks and ended up having to get dismissed. To bridge it over towards why do certain prosecutions fail and what you can do about it, and then I'm going to tell you some good stories about successful prosecutions. Many of the things have already been mentioned. Thoroughness of reports, understanding the elements, knowing what you can prosecute or prove and what you can't. Certain things are more complex at the federal level that you would require a boat, or if you're on a beach patrol or something, there are many statutes already on the books in the state that you can help assist in giving reports for, and hopefully precluding that conduct in the future. These include types of netting, types of fishing, spear fishing in a conservation district, those types of things. One other example, though, very briefly before I get off the failures, is the reason prosecutions failed. I've talked about kind of like the elements and the understanding of the elements, such as the take, or in certain instances, that the statutes are just very poorly written. And that requires environmental attorneys to come in and revise them. These statutes on the books are very effective, but they are also a bit draconian in how they are old, and they provide punishments for a year in jail or 6 months in jail. At this point, you want to focus more towards incentivizing or towards administrative penalties in which you don't have to have the threat of jail. So for throw netting, lay netting, gill netting, there's so many types of nets that are prohibited in the state of Hawaii for certain reasons. But the statute says This type of net cannot be thrown and left in the water for over 4 hours, and you have to check on this type of net every 2 hours. If you don't do that, you're in violation of this law. To prove that would require an officer to sit there for 4 hours and make sure that you didn't come back and check the net. That's not gonna happen. But let's now transition to a great success story, and it's one of the counterparts of where you all are going tomorrow is Pupukea. We had a case come through our office for Hanauma Bay.